Welcome to Plan on It.
Welcome to Plan on It with attorney Christopher E. Botti, board-certified specialist in estate planning, trust and probate law, and founder of Botti and Morrison Estate Planning Attorneys. I'm Leanne Lyon, and today we're talking about the major Medi-Cal changes taking effect in 2026 and what they mean for California families planning ahead for long-term care. This is episode 1, Medi-Cal changes for 2026, what California families need to know now. Chris, for listeners meeting you for the first time, can you share a little bit about your background and what led you to focus on estate planning and Medi-Cal law in California?
Sure. First of all, let me say I'm extremely excited to start doing this podcast series. I've been thinking about this for years, and I'm a real believer of providing content to our clients and potential clients through our website and other methods. And so this is I'm so excited to start this process and continue down this path and commit resources to it. So I appreciate the fact that people are going to be listening to this and providing feedback, because I'm all in as far as going forward with doing this for my clients and potential clients. So, all right. So what attracted me to estate planning? Well, basically since law school, and I went to law school from 1987 to 1990, I was attracted to this practice area. And the reason why is because when you get into this practice area, you build lifelong relationships with your clients and their family members. And the experience in general is positive. In other words, a lot of people who interact with lawyers they're doing it under stressful situations like a lawsuit, whether it's a criminal matter or a divorce or car accident, whatever. Those are stressful events. And so estate planning is an incredibly positive experience for not only the clients and their families, but also for me as an attorney. And so that was my attraction. But the problem was when I became an attorney, I was 24 years old. And so right from college, right to law school, and then boom, I actually passed the bar and was sworn in before my 25th birthday. And one of the most important qualifications you can have as an estate planner is life experience. And a 24-year-old person doesn't have much life experience. So I couldn't just jump into estate planning initially. I kind of had to go work for a law firm and just be a regular old lawyer doing billable hours and all that kind of stuff until I got a little more seasoned. And then in 2003, I formed the firm, Botti and Morrison, and devoted my practice exclusively from that point going forward to estate planning. And that was always been my passion, and I wanted to get there, but I needed to have the credibility to be able to, convince people that they should hire me to do this for them, because again, life experience is one of the most important things you can have, being able to relate to people, being through things, having, deaths in the family and other things that go on, that when you do estate planning, you're planning for that kind of stuff. And so for me, it was important to get a little more seasoned before I jumped into this completely. And then as my practice evolved, doing the regular estate planning, my clients started to get older. I've been doing this for 35 years as an attorney now. And so for a long time. And so clients start to age, they start to get concerned about what happens down the road if I get ill and I can't, and I don't have the long-term care insurance, for example. And I understand that, the Medicare program doesn't really provide much relief at all when it comes to potentially paying for long-term care costs. And so the morphing of my practice into more of an elder law-centric practice was the result of my clients simply aging and asking questions. And so during those interactions early on, when clients were getting to me, unfortunately, sometimes they got to me too late and they made critical mistakes, not knowing that there were options out there available under the umbrella of elder law to do Medi-Cal planning and protect and preserve their assets. So that kind of forced me to say, look, I need to reach out to my clients better and educate them more about these issues. And so that kind of got me pushed into the direction just organically through my own practice into the elder law arena. And part of elder law is in California in particular is dealing with the Medi-Cal program and planning for the Medi-Cal program. There were a lot of mistakes being made by my clients. I'm like, I need to do something to correct that. So that's the whole reason why I created the ebook that we'll be talking about, I'm sure, throughout this podcast, was to educate our clients and to make sure that they were aware of these issues. So it's my passion, and So that's basically how I got started in estate planning in general. And then it morphed into not only estate planning, but elder law, which I'm not a huge fan of that term, by the way. I think, it kind of like, there's a better way to describe that area, but I can't really coin a new phrase because it's pretty much ensconced now in is a term that we use to describe helping elderly clients plan for issues like, incapacity and tapping into these programs under the Medi-Cal umbrella.
I really appreciate how intentional you are, in addition to passionate for exactly what you're doing, that you really made some great decisions early on in your career to make sure that you would be ready and capable and be respected in the arena. I go back to 2020 and all the 20-year-olds who were suddenly life coaches were like, yeah, good luck with that, right?
Yeah, I mean, it's funny because when you do estate planning, you speak of life coaches, which is, I guess, I'm not sure if they're licensed. Any, that's an area where you'll actually have a license. But like part of the, one of the most important skills, and this is going to drive my wife crazy. If she was sitting in the room next to me, she would actually hit me if I said this. But one of the most important skills you can have as an estate planning attorney is listening skills. And my wife totally disagrees that I have good listening skills, but that's because I have selective listening when it comes to certain interactions we have, which is, I think, normal for most married people. But the idea of being able to listen to people and, hear out their concerns, that's really, really a big part of this also, so.
Well, let's turn our focus a little bit to Medi-Cal. The 2026 Medi-Cal update reinstates what's called the asset assessment. In plain language, what is changing on January 1st and why?
Wow. Okay. So it's very rare that changes like this happen in the law, and changes like this that cause like people to have to take dramatic action potentially. There's unfortunately a very narrow planning opportunity between now and the end of the year to engage in some planning that will go away, opportunities that will go away as a result of the return of these the Medi-Cal rules that existed prior to 2024. So what's coming back is the asset test and the look back period. And so the asset test is where the state of California, when you're submitting a Medi-Cal application, particularly under the long-term care Medi-Cal program, and there's lots of different programs under the Medi-Cal umbrella, but my clients are concerned about the long-term care program, that they look at your assets. And if you have what they excess resources, then you will not get eligibility under the Medi-Cal program. For the last 2 years, they didn't look at assets. So theoretically, someone who lived on the coast and had a $20 million home and tons of assets could get a Medi-Cal card. Now, why would they get one? That's a great question. They probably wouldn't because they can afford to private pay for long-term care, but they took away the asset test. And so that was an amazing thing in that it created a lot of ease when it came to submitting these applications because the state did not scrutinize at all what you owned. And so that's coming back as of January 1st, along with the look back period, where the look back period basically is where the state says, look, if you're going to gift or transfer assets in contemplation of trying to get help through our program and you do it improperly, we're going to penalize you. We're going to create what they call a period of ineligibility, which will delay your ability to tap into these programs. And so both those tests are coming back as of January 1st. And so the state gave us a gift, which in my opinion is creating a little bit of chaos for people like me, where transfers that occur between now and the end of the year do not trigger any look back whatsoever. So you can position yourself right now in your estate by making moves between now and the end of the year, which is kind of chaotic because we're looking at less than 2 months from now. Mm-hmm. You can do things that you're not going to be able to do as of January 1st. So.
Who will be most affected? New applicants or people already on Medi-Cal who have to go through a redetermination next year?
They're both potentially affected. That's the thing. I mean, those who are seeking new benefits as of January 1st are going to have to go under the old system. And existing applicants who were able to basically get a Medi-Cal card and obtain the benefits when they go through the redetermination process are subject to the asset test. And that's going to create a lot of anxiety for people. And it's just unfortunate the way the state did this in terms of designing the change in such a way that creates, I don't want to use the term chaos. I think the word chaos is a little too strong, but it is, kind of, difficult to deal with a this expiration that's going to happen as of the end of the year, and it's forcing people to have to make really profound and important decisions that apply to their families in a very short period of time, and whether they should make moves now or later. And really, the only way they're going to get peace of mind to get a true guidance in that area would be to speak to someone who's qualified to have a conversation about that, which would be an elder law attorney. So it's going to affect both. And it's going to affect us, and my clients.
And for those who did qualify and under the recent no asset test period, what will happen if they still have assets above the new limits when the rules change?
Yeah, so if they fail the test, then they could lose eligibility, which could be devastating. In other words, the statewide average for a nursing home care is pushing $15,000. That's just the average. Now, of course, there are facilities that charge significantly more, and there's some that charge less. But the point is, $15,000 a month of benefits that are being provided by the state could go away. And the number one reason why seniors go bankrupt is paying for long-term care costs. So this could be devastating. And so it can be avoided, though. There are things that can be done to eliminate the loss of eligibility, but you have to act now.
And in fact, you mentioned your ebook earlier, and it mentions exempt and non-exempt property. So what kind of assets can families keep without losing eligibility, and which ones typically create problems?
Okay, so basically under the old system, which I'm very familiar with, we practice it under the old system for years, decades. And so these rules that are coming back have been in existence for a very long time. And the planning techniques that we deployed prior to the removal of the asset test in 2024 still exist and are being brought back to life as a result of the return back to the old system. And so basically what happens is there's what is considered exempt assets. They don't count towards eligibility regardless of their value. And there's a laundry list of exempt assets. The two biggest are retirement assets in your home. There's a lot of misinformation that people think that you can only have $2,000 in your name. That's a myth. It's never been true, because there's exempt assets, regardless of value, don't count towards eligibility. And there's a laundry list of those. In fact, my ebook outlines about 13 different forms of exempt assets that you can have and not have it affect eligibility, and the values of those assets don't matter. So it's the non-exempt assets that count that you have to be worried about. And so everything else that's basically, if it's not exempt, by definition, it's non-exempt, and therefore you have to look at those assets. And when you do the analysis to determine whether someone could qualify for Medi-Cal, you got to create two columns of assets. One would be the exempt column, and one would be the non-exempt column. And so that we're back to doing that again.
Well, it sounds like you're well qualified to go back to the system that's now being reinstated, and that's got to be a comfort for people who are working with you.
Hopefully it will be a comfort. There's always been solutions. You just need to know what those solutions are. And there's not a lot of information out there. There's no roadmap, for example, being provided by the state of California in terms of how to navigate this. They would prefer that you do engage what they call spend down, which is spending down your assets to the point where you reach eligibility criteria. They're not going to advertise what elder law attorneys do. And by the way, everything we do is allowed by the state of California. These are sanctioned techniques that we can deploy, and we do deploy, and we will be deploying again as a result of the return of the asset test. But all those options are still available. And the key is that you need to know they're out there. And there's a lot of bad information to create this fear that you've got to have only $2,000 in your name before you can even get eligibility under the asset test, and that's never been the case.
So let's dig into a kind of a more specific scenario, which would be with married couples. How are married couples treated differently under these new standards, especially when one spouse needs long-term care and the other one is maybe still living at home?
Okay, so in my world, and in the world of estate planning and elder law, we call the person that's living at home the well spouse. And the person that's going into the facility or in a facility is the institutionalized spouse or the ill spouse. And so California is pretty progressive, and I really applaud them for this. We have gone to great lengths to make sure that the well spouse doesn't become bankrupt if one of their, if their spouse gets ill and needs to go into a long-term care facility and tap into the long-term care programs under Medi-Cal. And so we have these things called the spousal impoverishment rules that protect both assets and income. And so when you're dealing with a situation where one spouse is sick and unfortunately they're in a nursing home or about to enter a nursing home and one is not and they're at home, we can protect more assets and more income to allow that well spouse to be able to stay in their home, not have the fear of losing their home and be homeless essentially. And so these spousal impoverishment rules are there to help with that exact scenario. And so we do break out and provide additional protections for married people when one is ill and one is not.
Good. Wonderful. Well, I know you've helped thousands of Californians use trusts to preserve assets legally. So how does an irrevocable Medi-Cal asset prevention trust, that's a mouthful. I actually work under the 2026 rules.
Okay, so the irrevocable Medi-Cal asset preservation trust is a very important technique that elder law attorneys deploy. So before I get into what that exactly is, I want to kind of issue a consumer alert or consumer warning, especially in the environment we're in. There are a lot of individuals out there who are not attorneys who claim to be Medi-Cal planners. And a lot of them will cross the line and engage in the unauthorized practice of law. The creation of this irrevocable trust, the Medi-Cal Asset Preservation Trust, should only be done by a lawyer. It is the practice of law. And so, but there are individuals out there who will purport to engage in this kind of planning. They have no business doing so. They're not lawyers. And so I suspect there's going to be a lot of activity out there from those individuals promoting their services. It's going to create a lot of confusion in the marketplace. And so when you're doing estate planning, particularly with legal documents, you better have a lawyer do it for you because it's got to be done right. You'll never find out if it's not done right, if you're, because you're either you've passed on or you've become incapacitated. So it's really important these documents are prepared correctly. And so also these quote unquote Medi-Cal planners that are out there that are not attorneys, a lot of them are really about the sale of what they call Medi-Cal friendly annuities, which is a highly commissionable product. They're looking to make money through the sale of annuities. So there's a lot of things out there that the consumer has to be aware of that potentially get them in trouble. So when we do estate planning, right, when lawyers get involved in this and we create these irrevocable trusts, what we're trying to do is basically provide a vehicle in which when you have excess resources, which means you have assets that are above and beyond the limits you can have to qualify. And what we need to do is to move those assets into a protected vehicle so they don't count towards eligibility. And that's where this trust comes into play. It's a very important tool that we use because you just don't want to give away assets to anybody, because once you do that, you lose control. But by putting it into an irrevocable trust, it's exempt for eligibility purposes, but you're still maintaining control within the family, and the assets are not distributed on to the next generation until you that pass on. So it's a much better way to engage in this planning because you're allowing these assets to be exempt, moving them into the column of the exempt column, but in the same way you're protecting them from probate, and you're also protecting them from the creditors of not only yourself but your children. And so we don't just want to make outright gifts when you have excess resources, and that's why these trusts are being deployed. They're being deployed to protect the client so that the assets are in a vehicle that will provide them with security, knowing that they'll be available when the time comes for their families. But until then, they're set aside and protected for them.
Perfect. That's what people need to hear right now. So,
Yeah.
as we wrap up this first episode, for families listening who want to be ready rather than reactive, what is the best first conversation to have with their spouse, their kids, or an attorney to start preparing for these changes?
Well, the key is the first conversation, right? Like a lot of times people ignore these issues, and it's not necessarily the person who is ill who's thinking about, wait, what do I need to do to protect myself and plan for the long-term care, and how do we pay for it? usually it's not them that starts the conversation. It's a loved one or a child or another family member that raises the issue. So the key is with this kind of planning is full transparency and full family involvement. So whether it's a child or a spouse or a sibling or just a friend, you've got to start the conversation, right? And once you start the conversation, you start having a dialogue, then you realize, wait, we need to plan for this. And the way you plan for this is, having the communication within the family and then reaching out to someone who knows what they're doing to find out where you stand, what, if anything, you need to do going forward to protect yourself and your family, so that when the time comes you need to engage in this planning, you can do so without any restrictions, without the need to get the courts involved. And that's peace of mind. That's what this, at the end of the day, is all about, right? Estate planning and Medi-Cal planning and long-term care planning is all about obtaining peace of mind. And if you have that peace of mind, that you know that you have in place what you need to engage in this planning if needed, that's, at the end of the day, what this is all about.
Perfect. And that's a wrap for today's episode of Plan on It with attorney Christopher Botti. To access more resources, including the 2026 Medi-Cal ebook and upcoming estate planning workshops, visit boddilaw.com. Thanks for listening, and don't forget to like, subscribe, and leave a review if you found this episode helpful. Thanks, Chris.
Thank you so much. I really appreciate you, and I enjoyed this first episode. I'm looking forward to doing more.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.